Welcome to the Case Autopsy, the Verdict and Settlement podcast. With your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your host, Mike Campbell.
Welcome back to another episode of Case Autopsy. Joined again today with Tad Thomas. Tad, what's going on, brother?
I'm sorry you're getting stuck with me again, Mike. I know you try to get away from me.
You know what? It's awesome to have you fill in. It's better than me going out and trying to do this stuff on my own because, as you know, I tend to get lost in the weeds. And Chris has been on a hiatus because he's got trials and everything that comes along with running his own practice. So I appreciate you pitch hitting here, brother.
Yeah, I hate it when it's like stuff like real work gets in the way of fun stuff like recording podcasts.
Right. I mean, so it's kind of interesting because if you have a podcast like this and you want to focus on trials, you're trying cases yourself. And so it's just that balance of trying to get content out, but also doing what you can. And I mean, you're trying cases. Oh, and by the way, I think this will be the last podcast we do together before you are president of AAJ.
Unless we get a podcast in the next 3 days. Yeah.
It's always possible. We could do one out in Seattle, I guess.
Why not? Be fun. So yes.
I think today's podcast, we're joined by Kevin Biniazan, and he's going to talk a little bit, I think, about motion practice, which for a nerd like me is exciting.
Mm-hmm. Yeah, and it's a case involving a crime victim, and I'm a member of the National Crime Victims Bar Association, and in addition to AAJ, another great organization. And, these are cases that are handled differently, and sometimes there's not a pot of money at the end of the day. Sometimes there is. But some cases just, if you remember back when we had Vince Glorioso on the podcast,
right?
Said sometimes you just need to take a case because it needs to be done. You need to try a case because it's the right thing to do. So I think we're going to hear about that too.
Yeah. And the table setting aspect of these cases, just putting them into the best position possible for trial is different because you have a different type of blame shifting in these cases, especially if they're victims of sexual assault, than in your typical car wreck case where it's this person had arthritis or degenerative disc disease beforehand. It's a different type of blame. And so you have to be really careful with how you do all the table setting beforehand, before the trial starts.
Yeah.
And so hopefully Kevin can fill us in on how he did that for this case.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Hey, welcome to the show, Kevin. Why don't you tell our viewers a little bit about yourself and tell us about your practice?
Sure. Name's Kevin Biniazan. I work and own Bright Biniazan, a law firm that's based out in Virginia Beach. We have offices in Richmond, in Portsmouth, Virginia. I have a satellite office in Phoenix, Arizona, and we sort of service most of Virginia. And I take cases across the country, really based on sort of third-party crime, sexual abuse cases right now that are sort of unfortunately growing everywhere we look, but also try and focus my practice in our firm primarily on being a trial-oriented law firm that you can call on, whether it's early in a case or late in a case, to be able to come in and prepare and tee up and try a case as good as anybody else in the country.
And I can imagine it's difficult because Virginia is one of the few states in the country that still has contrib, right? And you probably get that question a lot, but how does that factor into whenever you're reviewing like one of these third-party premises cases?
It's tough. I mean, I think it's almost one of those factors that I think turns out to be if you want to think of a silver lining in it, and it's an added benefit, I think, with our firm and myself and our ability to evaluate cases, not just in Virginia, but elsewhere. because if I go into another state, when I'm always thinking about how I'm going to lose a case, right? And I think that's how most of us are to begin with. But that reality is much more real in Virginia when you're dealing with contributory negligence and you're, worried about that defense lawyer that's going to hold up a sheet of paper and rip off a corner of it in front of a jury and say, if he's this percent at fault, you got to throw him out, which I've seen in front of a jury many times. And so you're always looking for that tiny fact, that small issue that's going to be or could be your Achilles heel. And it requires, I think, you to be very vigilant in case selection in Virginia, but also really analyzing the issues and trusting the jury at the end of the day when you get close to a trial to be sure and confident that, listen, technically, could we lose this one on contributory negligence? Maybe, but if we focus group the case enough, if we've prepared it well enough, and we know that it's sort of juror proof in a way that we feel that a jury is going to understand the issues and not pour us out, it gives us a lot more confidence. So I think it can be a silver lining, but it's especially in premises cases and third-party crime cases, there's a tendency to attribute harm or blame to the individual that suffers the abuse, assault, or some other instance. And so it's always something we think about from the get.
Yeah. And one of the cases, and the case I want to talk about here today, involved your client, Yeardly Love, and her family. Could you give us a little bit of background about what happened in this situation?
Sure. This goes back 12 years now. It was Yeardly Love was a University of Virginia lacrosse player, and she was getting close to her senior year or finishing her senior year at the University of Virginia, about to graduate. And on the evening, in the late hours on May 2nd of 2010, her ex-boyfriend, George Huguely, had kicked the door down to her bedroom door in her apartment, broke in and murdered her and killed and murdered Yeardly Love in her bedroom. And she was pronounced dead that night when the police found her at about 2:15 in the morning. But that it turned out to be an 8-minute window in which George Huguely had, excuse the way I say this, but this is the way I describe it to a jury, but viciously attacked and battered and beat Yeardly Love to death, his ex-girlfriend. And that 8 minutes didn't really describe everything, because it really went back 2 years in their relationship. And it was really a case about domestic violence and a case about warning signs and issues in this relationship and issues that he's had in the past that really culminated in this night in May of 2010.
And you were talking about how you have to look at every fact and every detail, especially when you're looking at contributory negligence. I'm sure that informs your and the other side's motion practice, trying to get this fact in or this fact excluded. Could you tell us a little bit about the motion practice in this case leading up to the trial? Sure.
Yeah, I mean, this is a case that I had the great fortune of working with a couple different law firms on, the Canner Grana firm in Richmond, Virginia, and Paul Beckman and his firm from Baltimore, Maryland had been working on this case for years, really before I was involved. I was asked to come in and help try the case in about January of 2022. And at that time, we already had some motions set and teed up to be heard. And I'm sure many of you guys are familiar, people who are listening, in cases like this, a lot of them have to do with character evidence issues in terms of how much of this perpetrator, George Huguely's past, what his bad acts were, and how much of those actually get to be shown or talked about in front of this jury, and for what purpose. Some of it was also preventative on our end to try and make sure that sort of victim blaming issues weren't going to become, in the federal rules of evidence, we have the rape shield laws and these issues about what can and cannot come into evidence when you're talking about a victim in a rape case, but not all of those apply in Virginia. And so there were some motions that were also filed in regards to that. But it was pretty broad. I mean, if you want to think of it from a sort of a wide lens, the case involved motive, most importantly, motive and intent of Huguely. And because we were trying to establish punitive damages, willful and wanton conduct in Virginia, so that we could, and we could talk about this later, so that we could leverage that in a potential bankruptcy filing, which we anticipate or did anticipate would come down the road. And so it was critically important for us to make sure before we even got in front of a jury that we were confident that we were going to be able to use some bad actions or bad acts that he had in his past to try and paint this picture that this wasn't just a fluke incident where he really didn't mean to kill her, which was the defense in this case. The defense was that he was drunk and clumsy, and while he may have struggled or got into a slight altercation with her, that he had no ill will or malice or any willful intent to actually cause her harm. And so a lot of our evidence was targeted on that, and a lot of it had to deal with motions practice beforehand.
And so knowing that your goal here is, one, to find justice, but also within that framework to get punitive damages, what were some of the rulings that you got? And based on those rulings, did that affect your strategy going in? Did you have to sort of shift gears or change your mindset about what your ultimate goals were?
Yeah. So if it's okay, let me paint a little picture in terms of the background to try and give the listeners an idea of sort of the legal issues. The case was essentially an intentional tort case, a battery and assault case against George Huguely. And in Virginia, intent crimes or intent torts, battery or assault, are general intent requirements. So it's not as if we have to prove that he intended to kill, like in most states. It's just that he intended to touch, and that touching was unwanted or offensive or some way. There's a sort of a technical battery that's how I argued it in motions, because the defense counsel took sort of a nuanced defense in this case, which was to admit to a battery, and what I then called a technical battery, to try and, I think, remove a lot of the evidence from being heard by the judge or from the jury, to say that, hey, we've technically admitted this battery. We don't really need to get into the details here. And it doesn't matter what he did in the past because we've technically admitted to this battery. And so they were trying to, I think, not in some ways, maybe a strategic move to take bullets out of our chamber by admitting to a technical battery. And their whole theory of the case was that this was an accidental fall that occurred during a struggle between two drunk college kids. Okay. And so they had hired a biomechanical engineer and a toxicologist and a psychologist, 3 experts, to come in to say, psychologist, that this guy had bad impulse control. He just didn't really know what he was doing, especially when he was drunk. Biomechanical engineer to try and support the theory that the force that could have been caused by a fall was enough to kill Yeardly Love. And a toxicologist to say that George Huguely was so drunk that he couldn't have formed the intent to actually commit this crime, or to commit malice, or to commit willful wanton conduct, and that he was so clumsy that he must have just fallen. And so I called this, I forget what I call it, in closing arguments, I refer to this as their cocktail, their alibi cocktail is what I called this in my closing arguments. Is to say this is their alibi cocktail, which is, I don't know any better. I was too drunk to know any better. And oops, I fell kind of thing, which really educated at least me, coming into this case later in the game and understanding and being able to grasp those defenses. It really educated us, I think, in our motions practice, because it became to me very important that there were certain prior acts that he had committed that were related to Yeardly Love. There was an instance where he was choking Yeardly Love on a bed a few months prior to her death. There was an instance where he beat up a lacrosse player teammate, George Huguely did, about a year before, because he thought that teammate had slept with Yeardly Love. Those facts became a lot more important, I think, to us to be able to prove this malice, this willful conduct.
So you have two instances in the past of at least two instances in the past of violence that cut back against their defense and goes to your intentionality. What happens with those two prior incidences and the other ones? Do those two come in based on what you just explained?
They did, and those two did, and I mean, I was ready to die on the hill with those in argument. There were other instances of him being intoxicated and having been arrested and being intoxicated and having committed assaults on other people around campus, or just generally being aggressive, that didn't come into evidence. And in motions practice, I sort of treated those as a straw man. I felt that those were instances that I didn't need in the case, and frankly could have created an appealable issue if we had them in the case. And so I wasn't so motivated to have those be shown as evidence, as much as I thought it was important in motions practice and an argument to the judge to identify all the different instances where this becomes an issue in terms of his intoxication and his aggressive behavior, to then be able to distinguish, not only is it bad, but it gets really bad when Yeardly Love is involved. And that's where I tried to focus the argument when we talked about those two instances that I brought to you. And the judge was very nervous. I don't want to say nervous, but very, I think, apprehensive or appreciably, I guess, cautious when ruling pre-trial to admit that evidence. Because listen, we didn't have a witness on the stand yet. Most judges, at least that I deal with, say, well, I'm just going to wait to see what the evidence says at trial, and they sort of punt. But I pushed the judge in argument, in motions. I said, listen, we need this. Not only do we need this during the trial, but we need this before trial, because it's going to educate us on what we can tell the jury in voir dire. It's going to tell us what we can tell the jury in opening statement. And these are salient facts that if one of us leaves out, could really prejudice one of the parties if we don't address it either favorably or disfavorably in opening statements. And the judge ruled that, and not because it was a prior bad act that showed that he had this propensity to be drunk and violent, but because those two instances involved Yeardly Love specifically, and that there was a defense in this case that the incident that caused her death was not willful or was not malicious to justify punitive damages, that his prior malicious or willful conduct when Yeardly Love was involved was relevant to be able to show his motive or intent on May 2nd when he kicked down the door to her bedroom.
Defense tried to, walk this very thin line, and it sounds like it didn't work out for them very well.
They did try and walk a very thin line, and there's actually there was a back and forth during the motions hearing where the judge, I think, was really trying to figure out what this defense was, because we were, I kept calling it a technical battery, and I said, Judge, they're just admitting to a technical battery. We need to be sort of wary of this. And the judge turned to defense counsel at one point during argument and said, just set it straight for me. Are you saying that there's an assault and a battery, and that assault and a battery was a proximate cause of the death? And they admitted to it. And then things started to change a little bit after that, because, this works both, I think, in oral argument in front of judges, but also obviously in front of juries, where you just got to call it out sometimes. You just got to call it out when someone's in the shadows and trying to lurk behind the scenes and say, hey, they're trying to wait in the shadows over there. Like, let's shine a light over there and really try and figure out what they're talking about. Because once we really know what they're talking about, it doesn't make any sense.
Yep.
And I think it backfired on them. I do.
Kevin, in a case like this, you sue this college kid, right? Are there assets there? Were there other defendants? Why do you take on a case like this?
There were other defendants early on before I was ever involved. There were attempts to try and attach liability to the University of Virginia. They were both athletes under Title IX theories and other related theories. Those weren't successful because of legal issues regarding notice and things like that. I can't talk too much about the 10 years before me, but I can talk about January when I got the call.
Mm-hmm.
And for me, when I got the phone call, I knew and expected, I didn't know, I expected that representing this family and trying this case would likely never result in a fee for me. I knew that. I think going in, I expected that going in. But it seemed like such a raw and important and just big moment for this family, and frankly for that community, and for Virginia. It was a national story when it happened, and it sort of died by the wayside. And for the last 10 or 12 years, this there were still claims that this was accidental and that you didn't really mean it, and that irked me. And when I spoke with the family, I know it bothered them, right? I mean, you can't lose your sister or your daughter and hear that and be able to sleep okay at night, knowing that these claims that what we did or what this man did were just, I was too drunk. And so personally, I sort of went in excited and eager to try a case for a wonderful family and try and achieve a result that I think spoke to her life, and try to remove her legacy from the legacy of the actions that caused her death. Now, there's always the reality or the practical aspect of practicing law, which is it recoverable? There were DEC actions that were involved early on in the litigation before I was ever involved, including a large policy, homeowners policy in Maryland that was ultimately lost in Maryland. There's a smaller insurance policy that was still in play. And rumors have always spread about whether Mr. Huguely and his family had a lot of wealth. There's belief that there is income and assets that were removed from George Huguely at the time that this happened. And we do, sitting here, I think, what are we now? 3 months, 2 months post verdict. We're hopeful that we can come to some sort of a resolution in light of the verdict. And we're hopeful that we can do that not only to the benefit of the family, the Love family, but really hopefully we can do it in a way that benefits the Love Foundation, the One Love Foundation that they've started to sort of educate young adults about the risks of domestic violence and the signs involved.
Tell me real quick about the families. This guy, he's going for 35 years, I think it was his sentence. And then, then you have a family who's going to go through this civil litigation for 10 years, was that their motivation, that even though he pled guilty there, he was still trying to say that, it was an accident and they wanted a jury to say that this was what happened?
I think it's twofold. I think I think that's part of it, and their the other part of it, I believe, and when I got involved, what motivated me was that, when you go through the criminal justice system, and you guys know this, and representing sexual abuse survivors, I know this firsthand from their experiences, it's rarely about them. You may have a moment or a few minutes of time to provide your victim impact statement or how it's affected you. But the justice that's provided to punish this individual, it rarely acknowledges the actual harm and loss that's been suffered by a family or an individual who's had something taken from them forever. And I think in their heart of hearts, I think the family just needed somebody to say, we see you, we hear you, and we know you're hurting, and we know that there's nothing we can ever do about that, but we want to acknowledge you and acknowledge your loss with a verdict. And I do think that went a long way for them.
And when you were talking earlier about the importance of the punitive damage aspect of it, was proving that it was wanton, willful, the motivation of the family, so that you could also tie in punitive damages that can be discharged in bankruptcy? Or was it kind of a combination of, we want to make sure everybody knows this wasn't accidental, we heard the facts, and this was intentional? Was it kind of twofold, or what's the legal strategy, I guess, behind the punitive damages?
Yeah, I think it's twofold. I think there's certainly the, if you want to call it the non-legal or the public aspect of it, which is to try and put an end to this claim or idea that this was somehow accidental. From a legal perspective, it turns into it turned into both pre-trial and at trial a very nuanced issue for us, because in Virginia, punitive damages are capped at $350,000 statutorily. So you can get a $200 million verdict on punitives, and judge is going to write you a judgment for $350,000, and you can't tell the jury. You can't look at the jury and say, hey, all I get is $350. You're statutorily prohibited from doing so. At the same time, in the bankruptcy code, there is an exclusion in terms of liabilities or that can be excluded in bankruptcy for willful or malicious injury. And there are rulings in the bankruptcy code that have found that intentional acts don't necessarily qualify for willful or malicious injury, because depending on the state, and willful or malicious aren't elements of an intentional crime, or an intentional tort. And so sometimes you have to retry a case in bankruptcy just to establish that there was willful or malicious injury. And so, there's no saying for certain that that's going to be avoided, because you never know who you're going to get in front of in a bankruptcy court. But we felt that, George Huguely was convicted of second-degree murder, which in Virginia comes with a jury instruction that requires a showing of malice. Now, when we get to the wrongful death civil case in Virginia, wrongful death actions are statutory. It's like that in most states, because people used to die and their torts died with them, and so there's all these statutes created in most states to be able to give beneficiaries this right of civil suit. And in Virginia, I think this is just a General Assembly error, but the wrongful death code doesn't require a showing of malice. It requires just a showing of willful or wanton conduct, or conduct that evidence willful and wanton behavior or reckless indifference. And so we felt that if we can have a jury come to a concrete finding of willful or wanton or reckless indifference and a showing of punitive damages, and we could couple that with a conviction of second-degree murder that required the showing of malice, that if we were to come in front of a bankruptcy judge, if we ever have to in the future, we felt that in briefing, when you put those two things together, you can say, Judge, a jury's already decided malice, a jury's already decided willful wanton. That's malicious and willful injury. Let's skip all of the necessary, trial procedures in the bankruptcy court and find that this debt and this liability is non-dischargeable. So that was sort of the legal strategy around trying to make sure we established and proved punitives. But it also created this sort of nuanced issue in terms of, I don't want, and it's not very beneficial to have a $10 million judgment for punitive damages, at least not in Virginia, because it really just turns into a $350,000 judgment. And so it created a factual issue in front of the jury is, how do we present a strong punitive damages case to get a finding of punitive damages, but not have the jury return a high punitive award and make their focus be on a compensatory damages award that would then be non-dischargeable in its full amount and wouldn't be reduced to the $350,000 statutory cap. I feel like I'm like talking on a chalkboard and like
I'm thinking
everywhere.
about the fine line you got to walk. Wow.
Right.
I mean, yeah, it's punitive, but it's not so punitive that it's punitive. So
yeah,
it's only punitive under the bankruptcy code. It's not punitive under Virginia law.
Yeah. I mean, it was a lot of time was spent around tables strategizing with our whole team. How do we say this? How do we argue this? How do we present this?
Yep.
I mean, we thought in detail. I thought in detail about what the verdict form looks like. In Virginia, in most situations, we just give them a general verdict form. Who do you find in favor of, and how much? And it normally just says, I find in favor of the state. I give this much in compensatory and this much in punitive. But that didn't really help us in a bankruptcy court because I didn't feel confident that we could point to something concrete to say there was a finding of willful or wanton conduct. I wanted like a box to be checked, And so then we started talking about, how do you craft the verdict form and convince a judge to sort of deviate from the norm in Virginia to be able to give us something we can use later.
I mean, first of all, the amount of high level thinking that went on in here is pretty extraordinary. And second of all, the fact that you have to worry about just the 1% that could be assigned to a victim in a case like this, I think speaks really highly of the results, speaks very highly of your and your team's trial skills and ability to see all of the potential pitfalls in a case like this. So excellent job, Kevin. Excellent job.
Thank you.
And Kevin, thanks for bringing up the One Love Foundation. Mike and I will be making a donation on behalf of the firm to the One Love Foundation.
Really appreciate that.
We're going to put a link in the show notes and everything as well. So anybody else that listens to this, I strongly encourage them to get on. It's a very, very worthy cause. So.
It is.
Kevin, I don't want to close this without giving you the opportunity to tell people how to get into contact with you, especially if they're sitting back and thinking, I wonder if this fact is a bad fact and they're in a comparative negligence state. You can emphasize the importance of really, really reviewing those bad facts. How can someone get a hold of you?
Email is what we all live by these days. So my email is Kevin, simple, just my first name, at B as in boy, trial.com. So it's Kevin at bbtrial.com. I'm on most of the social media platforms with just my full name. I'm on Instagram, Kevin Biniazan, B as in boy, Iniazan. I have a TikTok, even though I post more than I read. I have a Twitter, but email's the easiest way.
We have all options under the sun, but please email Kevin. And Kevin, thanks again for coming on the show. And everyone out there, please look at the foundation, and we'll have a link in the show notes so that you can give.
Thank you.
Thanks, Kevin.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Well, he certainly got into the details and logistics and technical aspects of it, and showed why it's important to work with a firm that does this type of work.
Yeah, a specialist in trial work. It's interesting. He wasn't called to get in on this case until January, and then had to jump right into a case that had been going on for 10 years and dig into it and get it ready for trial, and then have a result like this. It's an incredible story.
Yeah, it really is. And you can tell that he really, even though he came in just to try the case, he lived this case, I'm sure, from the moment he got it to trial, just thinking about every single strategy, walking that line between what you want the verdict director to say so you can avoid the bankruptcy, and also emphasizing the family's motivation of wanting to show that this was an intentional act. It's pretty high level stuff.
Yeah. And I really encourage everybody to check out the One Love Foundation website. We'll put the link up in the podcast. Obviously, you can Google it and it pops right up. But it's a really important organization for relationship abuse and fighting relationship abuse, and putting the information out there to talk to people about how they don't need to be in this kind of relationship, and empower them to get out of these situations before it turns into something like what happened to Yeardly. So.
Absolutely. Well, another good pod. I appreciate you again jumping on, and
happy to do it, man. Happy to do it.
We'll be singing "Hail to the Chief" the next time we're
better not.
All right.
You can buy me a drink though.
Yeah, sounds good, man. Sounds good. See you soon.
All right, Mike. See you next time, Mike.
That concludes another episode of Case Autopsy, the Verdict and Settlement podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.